welcome to the 5th edition of the MBA webinar series on the topic Electoral Act 2022, its implications for free and fair elections in Nigeria. We apologize for starting slightly behind schedule. It was due to some technical errors. In the year 2007, former President Yar'Adua openly admitted that the election that brought him into power was flawed. That public admission led to the setting up of the Justice Mohammed Committee on Electoral Reforms. The Justice Mohammed Committee led to the enactment of the Electoral Act 2010. After implementing or practicing the Electoral Act for 10 years, the National Assembly in January 2022 enacted the Electoral Act 2022, which was assented to law by President Warri. The Electoral Act has generated a lot of controversies, and as part of our effort, that is the MBA Warri, to promote public awareness, this webinar will look at its implications on free and fair elections. And to look at this, we have eminent legal practitioners who have been involved in elections at different levels. We have Paul Harris Obole. Paul Harris Obole is a senior advocate of Nigeria, called to the Nigerian bar in 1988, and is the managing partner of PH Obole and Co., a firm of legal practitioners based in Abuja. Welcome, Leonard Senior Advocate of Nigeria. We also have, as part of our panelists, Mr. Mike Igene. Mr. Mike Igene is a lawyer, the resident electoral commissioner, Akwa Ibom State, and also is a social rights activist. Mike Igene was appointed as the resident electoral commissioner in the year 2011, and he has been there since then. We also have, as part of our panel, Mr. Ikide Igelua. Mr. Igelua was called to the Nigerian bar in 1991, and he has represented clients at different levels of election petition, from the tribunal to the Supreme Court, in the past 2 decades. It's very vast in election petition related matters. Mr. Ikide, welcome, sir.
Thank you very much.
Well, gentlemen, we are partners for this webinar series is the Nigerian Law Publications Limited, which is the publishers of the Nigerian Law Report. After the opening presentation by our lead speakers, our partners will make a brief presentation for 15 minutes. For us to start off, may I invite Mr. Ikide. You have been involved in election petition for the past 2 decades. The Electoral Act 2022, part of the innovations that have been introduced is the introduction of electronic accreditation and technology. Can we say that we're at the level where Nigerians can expect to have free, fair, and credible election with the present legal framework?
Thank you, Mr. Omari. I am happy and grateful to MBA Warri for being a part of what is going on today. Now, let me start by making what I would call an opening comment on what we are looking at today. It is common knowledge, and we all agree, that military intervention in politics or intrusion into politics or political life of any nation is an aberration and anachronistic, and that we are not likely to have that situation occur again, even in Nigeria. Now, what that means is that the process of election has come to stay, and democratic governance is what the world is rooting for everywhere. Now, the issue I have with the Nigerian situation is that the bedrock of every democratic institution must be credible elections. If the selection process by which a man holds a political office is defective, then you are not likely to have a situation where leaders can be held to account or called to question. Now, we just witnessed last Sunday the long drawn-out electoral process in the French presidential election, leading to the re-election of the current president, Emmanuel Macron. Now, coming back to Nigeria, we all crave for democratic ethos to be entrenched. And we believe so much in our laws because conventions do not hold anybody to account in Nigeria. And so we must take a critical look at what the legislation just did in the Electoral Act. Now, back to your question. Electronic voting, whether it would improve the electoral process. Let me say this generally on the Electoral Act before I answer that question. That what I see in the 2022 Electoral Act is an attempt to perfect administrative aspects of INEC, and not much was done in respect of ensuring credible elections. Now, when the issue of the card reader was first introduced 2 election cycles ago, that would have been in 2015, we were actively in court when a decision came from Lagos State, a case involving Ambody then, and the Court of Appeal came out to say the card reader had no paternity because it was introduced through guidelines, not a substantive legislative process. However, I think the court did not advert its mind to the fact that those guidelines were subsidiary legislation. And so we suffered a serious setback because accreditation had to be done manually. And so they discarded the card reader to say you must go back to the voters register because that is the process of accreditation recommended and provided for in the Electoral Act. Now, I don't know whether you can hear me on the other side.
I can hear you. I can hear you clearly.
Thank you very much.
Yes.
So what they now did in 2022 is to try to entrench electronic voting, electronic transmission of results, and all of that. Now, in the last election, the presidential election, the major issue that was canvassed before the Supreme Court, right from the trial up to the Supreme Court, was the question of whether INEC had a server, if we all recollect. Until today, we have not been able to answer that question either from the laws or from whatever source we might try to look for an answer to that for. So let us now even come back now to what the Electoral Act now provides. I ran through the Electoral Act and I discovered that somewhere along the line, the voters register disappeared from the from actual voting process. What I'm saying is that there is no obligation to have a physical voters register on ground that will be ticked for purposes of accreditation on election day. We'll confirm that. Now, what that means is that we are going to rely solely on electronic accreditation and electronic transmission of the results of the election. I have my reservations about that. Even on this program that we are depending on electronics, on the network, we still see that some persons have problems connecting. I am in Lagos. Mr. Omari is in Warri. Leonard Silk, P.H. Ogbole is in Abuja. Now, we are having difficulties connecting. Now, what happens in the rural areas where you might have no network, poor network, and whether the kind of network you have there will be 3G or 4G compliant to be able to transfer data? And where is the data going to? So I have my reservations that no matter how much we want to jump towards technology, having seen the failure we recorded with the card reader, we have to be very, very careful going full blast on electronic voting and transmission of results because of the problems inherent in them. INEC denied that they did not have a server in 2019. Where is the data going to go in 2022? Maybe our brother Mike Egini will help us out with that. Thank you.
Mr.
Hello, sir.
Can you hear me?
Yes, sir.
Thank you so much for your intervention. We now have the resident electoral commissioner for Akwa Ibom State, our own Mike Igini. Rec, we apologize for the technical issues. I think that it underpins the essence of today's program. In summary, Mr. Kide has expressed concerns about the capacity, whether at our level of development, Nigeria can rely on electronic transmission of result and electronic accreditation as the sole means to determine who or to manage our electoral process. Let's have your intervention to the Electoral Act 2022. Can we say that we are at the level where Nigerians can have free, fair, and credible elections with the present legal framework?
Well, thank you very much. And I'm sorry for my co-panelists for some of the initial issues that perhaps delay my joining from the very beginning. But be that as it, listen to the latter parts of the conversation. I hope I'm heard. You're hearing me?
Yeah, very clear. You are very clear.
Right.
Very clearly.
I listened to the latter part of his conversation, and I agree with him some of the views he has, and I also use the opportunity to clear some of the views that he also expressed that are not wholly correct. But first, I want to commend the NBA Warri branch for this initiative. And I think that this is one of the ways we can contribute to defining what how 2023 should be. Because 2023 election is an election for new elite formation. It's not a second-term election. Those that will emerge from that election perhaps will determine what happens 4 years after 2023, perhaps 8 years, 16 years, or as the case may be. And that is why it is important that educating the Nigerian people, and particularly in Warri, where this is happening in Delta State, is very, very important. Now, on the issues he has raised, first, we commend the National Assembly, all stakeholders, basically, because we know how we got to where we are right now in having the 2022 Electoral Act. Now, what we have found in this Electoral Act, I would say from the point of view of the Commission, almost 80% of our proposals have been actually taken into account here. But more seriously, with respect to the issue about central server, I'm very sure that very many of you, you recall that when that debate, that issue came out, the position some of us took was very clear. It is not true that we don't have server. We have server. Nobody can say that. And I'm sure you all recall that there was the interview I granted. I didn't get that interview after the election. It was before the election as part of educating Nigerians on sound knowledge of democracy and democratic process, which is what we are doing now. Because I'm sure what my very senior colleague have said there, some of the views he has expressed, if we don't do some of those things, and by 2023, I'm sure people are going to play back the audio, the video of what we are doing today. And so it is not true that INEC do not have a server. We do have a server. Otherwise, all this huge data that we talk about, 73 point something million registered voter, 68.3 as at 2015, and 84.4 million at 2019. Where do we normally have those? So we have central server. Now, beyond that, some of the key issues he has mentioned with respect to his comment as regards section 47 precisely. We all recall that section 49 of the Electoral Act in the previous act was to the effect that simply a voter who intends to vote for upon presentation themselves to the presiding officer, if the presiding officer is satisfied, that language, is satisfied that is the person, we issue him a ballot paper for him or her to cast the vote. The question is, when we say a presiding officer is satisfied, what do we mean by that exactly? Because what we found was that, you remember that politicians were housing permanent voters card. They were breaking into INEC offices, sending people, boys to break the office to cut away permanent voters card, PVC. The idea was that as many PVC as you are able to get, you can commandeer people to somewhere and begin to give them a PVC that is not for them. So when they get to the polling unit, all you need to do, connive with the presiding officer, give PVC of other people to some other individual. So when he gets there, once he's satisfied, in quote, as said by the Electoral Act then, he will be allowed to vote. That was the mischief we tended to cure by introducing the card reader. That is to the effect that even though all INEC PVC could be read by the card reader, we have to go forward by trying to confirm your biometrics. Now, when people say card reader did not work, I can tell you here, it is totally not correct. Yes, we have issues, initial issues with card reader, but what were they doing? They were total sabotage. In the card reader, before we now have the beavers, what we had in the card reader was that in order to have what we call inclusive election, there were some applications that the user on the field, a presiding officer, you are not expected to press a particular button only after the election had closed. Because once you touch that button on the card reader, which is supposed to be done at the close of the poll, you will not be able to open that card reader again because it will require an admin password who is in the office, either in the state capital or in Abuja. That was a security put in there. But what happened? On election day, people, of course, insider information of our own staff gave to them. So early in the morning, on the day of election, that particular button by presiding officer, you coppers, they will just press the button, and they say card reader is not working. So they now want use of incident form. So a whole lot of issues, sabotage about card reader. Now, what has happened with section 47? Because I heard him say that register had disappeared. The views he expressed with respect to how the court, at the attitude of the court with respect to card reader, I agree with you completely, and I'm sure that my views on that as regard to the attitude of the Supreme Court was very disappointing. I agree with you. Yes, but right now, section 47 has taken into account, all right, the use of either the card reader, the beavers, or any device. Now, he also made the point that INEC, by virtue of the Constitution, we have power to make regulations, guidelines, which are subsidiary legislation, that has constitutional flavor, which of course the court then rejected. So now in our guideline, the register, what you call the actual hard copy of the register will be with the presiding officer. So it's not totally correct that, yes, whereas when you look at section 47, it will appear as if we're just talking about the use of the beavers without actual reference to the register. That will be contained in our manual and guideline for the election, because once a presiding officer now coming, a voter comes before a presiding officer in the new regime, as you would have seen in Edo State, Anambra, Ondo State. Once you come before a presiding officer, we now have more objective assessment, identification of who is actually the voter. This time around, assuming that your 10 fingers, we could not confirm we have now got what we call facial recognition. In fact, the second leg is what we call iris. But right now, we now do what we call facial recognition. One that is identified because it's going to pull out your entire data. When you register, it will show clearly, just as we are right now on the Zoom, I could see your face, you could see my face. That is now what we now have. So with that, the presiding officer will now be required to tick. You must tick that register. All right, as somebody who has been accredited. That is with respect to accreditation. Now, with respect to the transmission of result, please let me make it very simple here. You all recall that at the inception of the GSM, whenever you lost your telephone, your handset, the issue had already been, I lost my handset. That's why I've not been able to call you because I lost everything. But today, that is not the situation because the moment you have a new SIM in a new handset, because you are assigned to the cloud, everything will be there. Now, please look at my fingers. Look at my 5 fingers. The smaller finger, this is the polling units. A presiding officer, at the end of the poll, when the results have been counted, sorted, counted.
Reg.
Yeah.
Reg.
I'm hearing you.
We lost you at the point where you said with respect to electronic transmission of result. I think when you started a ham, we lost you. Maybe you can come in. That's very important.
Very important. I agree with you. In fact, that is the center of everything now. I am saying that by virtue of Section 50 of the 2022 Electoral Act, INEC is now required to now make the polling unit, because what we want to do, basically, I must say this to my colleagues here, that we want to end the business of election tribunal in this country. We want to end it. Now, the polling units, I was making the point that at the inception of GSM, if you lost your handset, the issue will be that, oh, my friend, I've not been able to get across to you because I lost everything. But today, that is not the situation. If you lost your telephone, once you get a new SIM, once it's activated, because you sign to the cloud, everything will come back immediately. So now what we are now doing, because I heard about transmission, the transmission in the general parlance people think about is that they are having an idea, that's why I'm showing my fingers here, that in an electronic form, something will be transmitted from point A, which is the polling unit, to point B, which is the Ward Collation Center, point C, which is the Local Government Collation Center, point D, which is the state collation, at all levels of collation with respect to State House of Assembly, House of Rep, Senatorial, and Presidential. But I'm not saying that, look at my fingers. What we are now doing is this. This is the polling units. At the polling units, at the close of the poll, once the results has been sorted out, ballot paper has been sorted out, has been counted, and the vote of each candidate openly announced, we now fill what we call Form EC60E. We must have what we call audit trail. There must be an audit trail beyond the electronic people are talking about. So now, use the beavers to take the photograph of the original Form EC. Party agents, observers, and voters themselves. Once it's done, after finishing that, he will immediately send that into the cloud. He sends it straight into the cloud and go to our central server. He goes into the cloud. And that is why today, if I open my system, the result of Ondo State, Anambra, Edo State, all the off-season election we have conducted, you will see all in the original format. In fact, with what we have done now, colleagues You don't need to even bother yourself about going to INEC offices, to have what you call initial document for if you are engaged as a counsel for election petition. You can print all of those things there before you now come to INEC office for certification. All right, because we need to cross-check that before now certify some of those documents for you. So now the beauty of what we are doing now is this. At the polling units, once that is done, and assuming that you don't have reception immediately where you are, all of you know your own personal experience. Now, when you send an SMS, once you press send, for any reason you don't have reception or not good enough, you cannot retrieve it back. The moment you get to where there's an effective reception, it will deliver to where you are sending it to. Now, 2, the ward collation officer, without having communication with the presiding officer at the polling unit where the voters are gathered, he already has a code to also view it, as we did in Ondo, Anambra. For example, in Edo State, we upgraded the INEC result viewing portal to accommodate 2 million people. 2 million people. And that's why in Edo election, Anambra, all those elections, whether you are an Agrarian, you are an Edo person, you are in Japan, you are in Germany, any part of the world, you have access to view. You can't change anything. You have access only to view the result. With that, then, so the work collation officer does not have to talk to you. So when he's coming he must come to the work collation center with the original document, the hard copy, so that what we are doing is a two-way system. Two-way system, both electronic, what we are transferring through the cloud, as well as the audit trail. So when it gets to the work collation officer, will betide him or her that she comes or he comes with results different from what he has himself viewed without contact with it. That is what happened up to the last point. So with what we have done now, the political parties, they can set up what they call their situation room to do their collation. The vision here is this: a time is coming, because in America, in other part of the world, where have you seen an INEC chairman, INEC resident committee, all these big titles we are carrying all over the whole place announcing results? We are getting to a point where, for now, the law does not allow any television station, media houses to announce, but they can collate it, they can display it, just as we are doing for increased transparency. That is what we are doing. So in due course, it's most likely that before INEC will make a formal pronouncement, the entire result, as you saw in Anambra, in what they call it, Ondo State, and several other places, you would have seen the entire result. So this is the message. And that is why I am so delighted that I was a bit very unhappy when we had the initial hiccup. We're trying to hook up, which are part of the things we are talking about. So basically, the best elections around the world are not necessarily driven by technology, but what we have seen, I can confirm, given our experience in all the jurisdictions I've visited across the world, is that good elections are electronically assisted, are technologically assisted. That is what we are doing. So we are being incremental in what we are doing, because we recognize that 80%, over 80% of Nigerian people are domiciled in the rural area where you don't have some of these facilities. And that is why we are taking some basic elementary, ICT, devices that can be operated everywhere. Because you ask yourself, how can India, with how many billion people, could do election without having issues? So this is the path that we are following, and I believe that some of the provisions that we find in the Electoral Act will actually bring a high level of integrity to the electoral process, so that the will of the people expressed through the ballot should be the best means truly of determining who should become what in our country. As we go on, I think the other profound provision that we have found in this Electoral Act, but basically, I must say this here, this is my caveat, and that is that as lawyers, we know that these laws are not self-executory. We know that innovations are not self-implementing. They have to be implemented by human beings. So the human agency is very key. In fact, the problems we are having with our election today are not necessarily as a result of lack of laws. The problem is that whereas there have been massive technical improvement on the part of the commission, but there has not been a corresponding change of behavior on the part of politicians who are the greatest threat to our democracy. As we are preparing for 2023, as INEC is innovating, in quote, they are also innovating. They also want to sabotage the current effort. And we have all the information of what they are planning to do. In Ondo State, they try to do so. In Edo State, they try to do so. In Anambra, they try to do so. We have built some level of firewalls. But the most important thing is that we are in a country, a very permissive society, where wrongdoing are permitted. But so far, a few of them we have used. 2 professors in Akwa Ibom State, one of them served 3 years J10, another one by tomorrow or so, we are going to have some kind of pronouncement by the court, who also think that they can change the results. So that's why Section 65 is very, very of interest here, because it's no longer possible that results declared under duress by anybody will allow people to go into the National Assembly or to occupy elective office. Because as I speak to you, you all know that in some states of the Federal Republic of Nigeria, there are people who are in public offices today on account of false results. That was what somebody tried to do in Akwa Ibom. But unfortunately, you can't try that easily and successfully under my watch. And that's why a professor is now serving a 3-year J term. One is still going to go, 4 staff have been dismissed, and that is the way we must go. And as we go on, I think that there are a few other parts of the electoral that I have found very interesting, but as I've also mentioned, we have particularly lawyers. We have a role to play here. We have a role to play here. Our colleagues in the bench, I must say this, I'm still carrying my placard in my heart. I am not happy. A number of them, I've met them, that the kind of technical approach they have used in dealing with election matters, I am so unhappy, because today, if you look at the country, and I work in the commission, police, I must tell you here, the kind of things we hear from politicians is shocking. A politician will come to an INEC office, will tell staff that, look, all we just want to, can you please talk to your guy? We can't talk to him. By tomorrow, 12 o'clock, there's going to be an order. All we just want you to do is obey the order. So surprisingly, you dismiss it. By 12 o'clock tomorrow, he gets an order. Politicians now are now having all kinds of order in their pocket, whichever way they want and all of that. So whenever we think that the new dawn has come, Awolowo said, if we are not careful, we'll be disappointed. Thank you.
Hello, Mr. Murray, are you there?
I'm there, thank you.
Okay.
Thank you so much, Rec, for that very incisive contribution. We now have our Senior Advocate of Nigeria, Mr. Paul Harris Obole. SN, welcome, sir. Can you hear me?
Thank you. Yeah, I can hear you.
Okay, thank you so much. We are very glad to have you. We had the initial technical challenges, and we started slightly late, so we apologize. You're welcome.
I hope you can hear me.
I can hear you. Before we invite...
It's such an honor.
Let's see, can you hear me now?
I can hear you, yes.
Okay, before we invite the Lansik to make his contribution, may I invite the chairman of the NBA, Warri branch chief, Emma Uti, to make a brief comment. Ordinarily, he ought to have made his opening remarks, but because of the technical challenges, he couldn't do his remarks. Mr. Uti, sir. Or Chief Uti, apologize.
Mike, it's a pleasure to have you around. The Lansik, Harris Obole,
Some of us can't hear you.
I can't hear him too.
Nancy, can you make a presentation now? Lost him. Okay, we'll invite the chairman later. Mr. Hide Higeloa, you have listened to the REC, and he has clearly outlined the steps that INEC intends to take to strengthen the electoral process, especially with regard to transmission of result. Though we ask the REC later, one of the issues that have been raised by one of our participants is the fear of hacking through the system, since it's a technological device. Do you think that that is a possible challenge?
For me, it is possible, very, very possible. But I think that should go to the REC, not to me. What I thought the voters register was doing was providing a backup and a corroboration for whatever was going on with the electronic device, which was not very perfect. So you could pick up number of accredited persons in the card reader, and in some cases, especially in elections that were done in 2019, 2015, we discovered that there was a uniform pattern that you could count the number of persons accredited on the voters register, and the margin of error was very, very minute between the voters register and the card reader. What I do not subscribe to is having a unilateral process which does not have a corroboration coming from within INEC itself to say this is the actual figure or number of persons who came out that day. This is the number we accredited, and this is what is reflected in the votes. Now, prior to this time, if I could go on with your permission.
Go on.
Now, prior to this time, there was this disturbing provision in the Electoral Act 2010. Every time we went to court to say there was overvoting in Unit 2, we were met with the question, the number of persons who voted there, are they more than the number of persons on the voters register? Because the 2010 Electoral Act defined overvoting from the point of view of number of registered voters in a particular unit. That has been corrected in this 2022 Act.
Right.
Where the number of valid votes exceed the number of persons who are accredited, it is now overvoting. We fought and fought over that, and they said no. As long as the register, the number did not exceed the register. And of course, it is almost impossible to exceed the number of persons in the register. But how many people came out to indicate their intention to vote? So that has been corrected in the 2022 Electoral Act. Now, Mr. Moderator, I know this question and answer series is beautiful, but let me run through certain things that I think are big pluses and then big minuses in this Electoral Act, so that we will get a picture, if you permit me, to do that. Yes. Now, we had a problem. I represented mainly petitioners in election petitions. And it was a very, very big problem for us to prove irregularities and non-compliance. Now, today, the biggest joy I have is Section 137 of this new Electoral Act. When you go to court to say, look at the result these people brought to, the number of persons accredited, the number of persons on queue, and the total number of valid vote cast exceeds what they should get, the court will tell you, go and call everybody polling unit by polling unit. So you will tell the presidential candidate, person challenging presidential election, like they were selling article in 2019, polling unit by polling unit. My brother, how many polling units do we have in Nigeria? That you will bring a unit result, you will now call a witness from each polling unit to come and prove that there were irregularities. We are taking the view that, look, this thing is documentary. Once you have reduced this thing into the form of a document, you can read the document and see whether there are irregularities. And now section 137 says you do not need oral evidence again if the document, the result, the forms used by INEC themselves show that such had happened. Another innovation you will find is in the proof of election petitions. I remember being in an interview for a particular location, and they asked me what my views were, and I said the unfairness on petitioners is obvious from the fact that every petitioner had 12 days to prove his petition. So the man who contested House of Assembly in some local governments, you have two constituencies in those local governments. The man has 12 days to prove his petition. The man who contests House of three local governments has 12 days to prove his petition. And then I go to presidential election, the whole of the country was a constituency, they had 12 days to prove. How was that possible? But if you look at the first schedule now, they have given time frames for you to prove. And in fact, the smallest there is that of House of Assembly, which is 2 weeks or 14 days. And so it has been graduated. And because of the scheduling, the pretrial conferences we do, you have find the tribunal telling you, no, you can't call this number of witnesses. Then if I happen to go to election tribunal again, I will insist on my number of days, which is now statutory. I know how to manage and how to call the witnesses I want to call, and not somebody stampeding me to close my case. Now, having said that, about some of the positives, let me tell you some dangers that I see in this electoral act. Now, section 31.5, I had litigated that provision in the 2010 Electoral Act up to the Supreme Court, where a person from another political party came out to say a candidate in another political party gave false information in his affidavit. This Electoral Act that has limited that provision, which is now 29.5, to only an aspirant in the primaries. And I think I have a little problem with that. It is against public policy for you to know that a man is cheating, and you cannot shout that the man is cheating simply because you did not participate in the primary election that produced the man who came to submit false affidavit to INEC. So I believe that any person as used in section 31.5 of the old Electoral Act should be restored, because that has to do with public policy. What it means is that even if the university came out to say this certificate that this man put here, claiming that it was given to him by us, was not given to him by us, that university has no local standard to go to ask for that man to be disqualified because the university or whoever did not participate in the primaries. So it's now dependent on whether the members of a particular political party will be ready to betray their own candidates and lose the opportunity. That, for me, is a problem. I discovered also that the two circumstances under which you may initiate these pre-election matters, jurisdiction has been vested exclusively now in the Federal High Court. In fact, today I received a brief and my juniors were calling me, where are we going to fight? I said, the new law gives everything now to the Federal High Court. I wonder why they did that. And I wonder whether the Federal High Court will not be overwhelmed. So matters arising out of primaries and improper conduct of primaries, the State High Court has no jurisdiction. It is the Federal High Court. If the man submits affidavit that is false and you want to go to court to disqualify him, the State High Court no longer has jurisdiction. It is the Federal High Court. So I wonder whether the Federal High Court has what it takes to cope. Section 84.12. Of course, we saw the disturbing interpretation given to it by the courts. And I think that we are trying to force an issue where there is no issue. What the Constitution before now barred was public servants, or were public servants running for election who did not resign within 30 days or 30 days before the conduct of the general election. Section 84.12 deals with political appointees. Now, the first of these cases in this series under the 1999 Constitution, where this issue was raised, was a case called Orji versus Ugochukwu. Theodore Orji, who succeeded Orji of Kalu as governor in Abia State, was actually chief of staff to the governor. the person who became the deputy governor was a commissioner. And so the issue was raised, the question was raised. If this person did not resign from this position 30 days before the date of the election, or they're not disqualified by the Constitution, the Court of Appeal said no. No, what that thing refers to is career civil service, public service. And I think that that provision was put there so that some persons will not have undue advantage in the electoral process. I do not appreciate and I do not understand the decision of the court that came from Umuahia where nullifying that provision, because there cannot be inconsistency where the subject matters of both laws are not the same. The Constitution relates to public servants. The Electoral Act relates to political appointee. No person who is a political appointee gets pension. A public servant gets pension when he leaves office. And we know the distinction that we must draw between those two. So I think I do not totally and entirely agree with those provisions. I think these are some of the things I have noticed and I've taken note of concerning the present Electoral Act. Let me yield for members of the panel to robustly discuss some of these issues. Thank you.
Thank you so much, Mr. Kiri. Lanasik. Oh, I've lost him again. Lanasik, are you there? Okay, Rec, can we come back to you?
Oh, yeah, right.
Well, there are a few concerns that some of the participants have raised, and one of the first one is the issue of hacking of this electronic process of transmission of results. That's number one. Then two, another participant has expressed concern that what of a situation where what you have in the hard copy, the unit result, is different from what is transmitted. What will happen in such circumstances? Then again, the question of you talked about it before, the human factor in all this. Let's look at this scenario, a situation where at the unit level, what you have as electronic accreditation is different from what is recorded as the number of people that were accredited. Can a ward collation officer, for example, on his own, without protest from political parties or any of the participants, take any action where there is such a difference?
Okay, thank you very much, Eric and the learners. First is to appreciate his observation, very clear one, and I agree with him in all the areas he pointed out, section 29 and all of that, very correct. There are issues of concern. Also, before I answer that question, issue of concern is the provision of section 135 that appears to have excluded INEC regulations and guidelines when it says that that an act which is not contrary to this act, without including that particular section, somehow excluded INEC guidelines and regulations. Don't forget, as the learned Seiko has been in election petition will have observed, in the entire constitution, as well as the Electoral Act, the word accreditation, you will not find it there at all. You will find that in INEC regulations and guidelines, such as well like PVC and all of that. You won't find them and all of that. So to exclude INEC regulation, I see that as a danger as we go for 2023 election. But to dwell on the area that we think we can advance the democracy to have a better election in 2023, let me clarify once again the issue of the use of the beavers for accreditation. Accreditation is a two-way process that we are using. Both the device, which is the beavers, as well as the hard copy register. It is the first stage is for your PVC, your data to be confirmed with the beavers. Then the second stage is that it must be marked. It must be ticked on the register. Look, let me say this here, step back just quickly. In the 2019 election, You see, some of the things that we are now hearing in 2019 election, I applied those things in Akwa Ibom State. And that's why some people had what they call the dinosaur experience. They were not used to this before. They were used to writing results. But I was clear to them that that was not going to happen. This process we are talking about is being under pilot. And I used it in Akwa Ibom. In the senatorial district where Akwa comes from, it has 10 local governments. I deployed the corridor massively with the tracking system. So when they arranged to snatch massive number of ballot papers away, what they failed to understand was that I had that process in place. What we did was that his opponent was leading with about 38,000 votes. He was trailing behind in 9 local governments, using this system that it has not become a public thing now. So after that election, he went to do all the manufactured votes, and he came up with only one local government, Esienudin, where he comes from, and he came up with 68,000 votes alone. So I said, no problem. There were hoopla across the country because he had been a 2-time governor, had been a senator, so they believed that he will win the election, but they were writing results. Basically, in Akwa Ibom, they'll be writing results. This view, I've said that publicly, but since 2019, it's a different thing. So what happened? We brought the corridor to query the corridor. We query the corridor, audit it, vis-a-vis the hard copy register. And you find out that the total accredited voters there, we're not even talking about valid now, was about 9,000. Can you compare 9,000 to 68,000 something that somebody manufactured? This was because the corridor was compared with the hard copy. That is what we are doing now. What we now have is that we now have an upgrade with the Beavers. At the Isoko constituency election, let's take it home to Delta, one of the areas we have done a pilot. That federal constituency election that was conducted by election, a lady came to the polling unit with the permanent voter's card of her mother because it has basically defaced. So you cannot really see the picture very well. But that was one of the pilots we carried out with the Beavers. So when she came, the minute she called her name and put on the system, she was asked to please go away. This is not your PVC. She was trying to argue. They opened the system and we pulled out the picture of the mother when she registered in 2011. She was not arrested. It was a case that I beg you. That was how she left the place. So in all the elections we have had, Leonard Sick and co-panelists, 2023, what we are doing is a two-way system to check it. Once you go to the Beavers, you must go to the, the hard copy register. Now, with respect to the issue about hacking, we have, since after 2019 election, we have been piloting this whole thing. There's no single incident of hacking. It's not as if they may not be making an attempt. But the question of what we have told you people is that, and that's why I use the finger to demonstrate here. We are not doing anything in form of a transmission from A to B in that order. No, we basically just upload. We upload that result into the cloud. That is what we do. We upload it into the cloud, and not a kind of electronic process of when A to B to C in that order, in which case, in between, there could be a kind of introduction of foreign result. You know what basically happened before? I have been that when the presiding officer will be leaving to the work collection office center, at some point, they will either introduce a new result entirely or change the result, or at the venue of the work collection center, they will security will assist them to ensure that party agents of opposition are not allowed to enter the venue. Now, part of what the politicians are planning now is that that's why War Coalition Center has only been the center of massive violence. Right now, with what we are doing, they are now trying to introduce violence now to the polling units. We're already seeing some signs of that. And that is where all Nigerians, we all have to come together here, because we want to end the process of saying that a governorship election in Nigeria, for you to be a governor in this country, you have to go through 4 stages. First, you go through INEC process. Second, you go through tribunal. From tribunal, you go to the Court of Appeal. From the Court of Appeal, you go to Supreme Court. Why so? Why so? For governorship and all of this process, corruption have been part of this whole thing. And we want to end that business. The will of the people.
You are muted. You are muted. You are muted. You are muted, sir. You are muted. You are muted. Okay.
Sorry. I'm back, right?
Yes, sir. Yes,
I'm
sir.
back. So
Yes,
what
sir.
we are doing now is to bring openness. Because if you look at the tribunal we are talking about, you know, to be a petitioner in this country is like we are out to kill a petitioner. Petitioner will be subjected to all kinds of things. And that's why when we say election is sui generis, I have asked this question, and I've told a couple of our colleagues in the bench that the burden of proof, all our innovations, and we are part of that. I will deliberately, we made certain suggestions in the commission that how can I conduct election? At the end of the election, the person at the return will not be the first respondent, either will be second respondent, or the other will be second respondent. The burden of proof, who should be the one to explain if there are issues raised, whether election was well conducted. It's our humble view that the burden of proof should be on INEC to be more responsible, to be more accountable. Because if you look at section 131 of the Evidence Act, and I've called a number of our colleagues in the bench, it simply says that whoever asserts the existence of facts must prove that those facts exist. That is one section 131 says. Now, please underline the following. Whoever asserts the existence of fact, not non-existence. And let me break it down. If in 2 local governments, a petitioner is saying, in making an assertion, that election did not take place, there was no election. There was no, because first, what's an election? Election is a generic process that have basic constitutive elements of accreditation, voting, sorting, counting. Once all these due processes are not present, you cannot talk about election. Now, if somebody is returned as a winner, he will normally say there was an election. So he is making a positive statement. Who are